Welcome to another edition of International Law Behind the Headlines. I'm co-host Catherine Amirfar, and in this episode, I speak with former State Department legal advisor John Bellinger. John, we're going to talk about the decision of the International Court of Justice in Iran versus United States, also known as the nuclear sanctions case. As you know, the court unanimously approved provisional measures in October, directing the U.S. to remove certain export controls on humanitarian goods. Can you go through from your perspective what the implications or import of that decision has been for the U.S. on one hand and also for the ICJ as an institution?
Sure. And Catherine, it's great to be with you and with the ASIL audience. Of course, you and I kicked off more than a year ago the ASIL series on the Trump administration and international law and tried to look into the crystal ball about things that might possibly happen. And we talked about international institutions and treaties. And of course, some of these actions now have begun to happen, including some treaty withdrawals. So in this is the third of three cases that are now been brought against the United States before the ICJ, two of them by Iran. And this is the first decision in the three cases in the nuclear the nuclear sanctions case. The ICJ, of course, has ordered provisional measures against the United States, telling the United States that while it's not going to, the ICJ is not going to order the United States to stay in the entire Iran deal, the JCPOA. It has to continue to provide humanitarian and agricultural supplies and aviation parts, and has ordered the United States to do that as a provisional measure. I was somewhat surprised that the court even went that far, because having a court in The Hague wave a red flag before the Trump administration with respect to one of the signature initiatives of President Trump, his withdrawal from the Iran deal, even essentially adjoining just this small part of U.S. sanctions and requiring the U.S. not to lift these sanctions. I was surprised that the court even went this far. And of course, it got an immediate reaction out of the Trump administration, which said that it would now withdraw from the Treaty of Amity between Iran and the United States, and so that Iran could not sue the United States again. So it did get an immediate reaction from the Trump administration, but the Trump administration has not gone farther. I worried that they might overreact farther and to pull out of the case altogether and just to refuse to go farther. And I suppose that is still a possibility, but at least right now, the court has gone farther than I thought they would. The Trump administration, not surprisingly, has reacted. But as you know, Catherine, I did write recently in a blog post that it's perhaps not surprising that the United States has pulled out of the Treaty of Amity, because this is the third time now that Iran has sued the United States under the Treaty of Amity. And if they're going to keep doing that, it's perhaps not surprising, and in fact, I would support it myself to have the United States pull out of the Treaty of Amity, given that there does not seem to be much amity now between the United States and Iran.
So, John, let me ask, because you expressed surprise that the court went that far, because there's some that look at it as an example of restraint. You suggested this as well, but the court was pretty conservative in terms of what it required the United States to do, since as a domestic matter, the United States has already removed impediments to the export of humanitarian goods to Iran. So as a practical matter, what would the United States have to do in order to comply with that judgment? That's pretty straightforward, wouldn't you agree?
I would, and I think that must have been what is in the minds of the court. And interestingly, it was unanimous, including the ad hoc judge selected by the United States, Charlie Brower. So all the judges said that the United States, while the court was not going to require the United States to stay in the Iran deal pending resolution of the case, the court did say that you must continue to provide these humanitarian, agricultural goods and spare parts. So the court obviously felt that they could go that far without risking a enormous reaction from the United States. I mean, even that, frankly, was risky for the court, because knowing this administration and with John Bolton as national security advisor and President Trump as president, there were certainly some risks that the United States could have just pulled out altogether, and I think that, frankly, sadly, is still a possibility. But as you point out, if the United States were acting pragmatically and realistically, it's not so hard for them to comply with this narrow requirement, because there were already licenses provided by the Office of Foreign Assets Control that allowed humanitarian agricultural goods to continue to go to Iran. So it shouldn't be too hard for the United States to comply. I'm quick to say this is not, I don't think the United States is instantly in compliance. There's some difficulties around the edges as to whether the United States must provide humanitarian goods or agricultural food to specially designated nationals, say the IRGC or others. But the United States should be able to comply with this, and I think that was the calculation that the court was making. The risk was that rather than making a sort of rational decision on that the United States might simply ideologically say, we're just not going to listen to a court in The Hague tell us what to do or what not to do, whether it's easy to do or not. What we don't know, and we haven't seen anything in the paper about this, is whether there have been huge internal battles in the administration about this. One could normally expect, I would hope, that the State Department would be saying, certainly the legal advisor's office, saying, look, this is not too hard to comply with, let's comply. But there could be others in the administration saying, we don't want the ICJ to be telling us to do anything. But at least so far, other than withdrawing from the Treaty of Amity, which we can talk more about, the administration has not said or hinted that they're not going to comply with this narrow order.
John, can you play out what the ramifications would be if the United States takes the additional step of dropping out of the case?
Well, you and I talked about this a year ago, Catherine, and I continue to worry about this, that, this administration is so hostile towards international courts and threats to American sovereignty that the administration might decide to not appear or to pull out of any of these three cases, the two cases brought by Iran or the one new case brought by the state of Palestine. So taking just this particular case, the nuclear case, the United States could decide either now or perhaps after the next round of briefing and hearing, that if the court decides that notwithstanding U.S. objections to the jurisdiction of the court, that the court is going to move forward. Suppose the administration could say, well, we're just not going to continue. We object to the jurisdiction of the court, and we're just not going to go forward. That's, of course, what famously happened more than 30 years ago in the Nicaragua case under the Reagan administration, when the U.S. government appeared at the jurisdictional phase, and when it lost on jurisdiction, it simply pulled out and did not go forward. I'm sure that John Bolton, who was around during the Reagan administration, is mindful of that. He referred to that case recently in a White House press conference, and so I'm sure that there are at least some in the administration who might be thinking, why should we even continue to participate in a case before the ICJ that has been brought by Iran? Again, hopefully the State Department, led by legal advisor Jennifer Newstead, will be arguing that the United States should stay in. We've got good arguments. It shows our commitment to international law, and even though we don't like this case, we think it's a misuse of the Treaty of Amity that the U.S. ought to stay in the case. But I do worry that there could be voices arguing in the administration that the U.S. should just pull out.
So, John, let's turn to the Treaty of Amity. As you know, it covers a broad array of relations between the United States and Iran, and has since 1955. It covers, for example, economic relations, consular rights, and bilateral affairs. What is the result of the U.S. withdrawal from this broad treaty in your mind?
Well, I don't think it's I don't think it's going to be an enormous effect. In fact, really even much of an effect at all on the United States. And in fact, I've been scratching my head trying to remember when I was legal advisor whether we had much discussion about whether the United States should terminate participation in the Treaty of Amity after Iran sued us in the famous oil platforms case. But we continued to stay in over all these years. I believe that the reason that the United States stayed in was that we continued to believe that there is friendship and amity between the American people and the Iranian people. It's simply that the U.S. government has been unhappy for 3 decades with the actions of the Iranian government, but that the friendship for the Iranian people remains. And so, therefore, we've stayed in the treaty to hold out hope that relations could be restored. The treaty does provide, obviously, rights for to protect Americans in Iran with respect to commerce and consular rights, but those benefits are so minor that given the cost of having Iran continue to sue us multiple times under the treaty, and there being virtually no practical benefit for Americans to stay in the treaty, and really very little even ideological benefit to say that we are staying in a treaty of amity, then what benefit really is the treaty? So while I'm not a big supporter of withdrawing from treaties, if they're not serving our purpose and in fact are only hurting us, it probably makes some sense to have withdrawn. And I'm not surprised. If I'd been legal advisor, I probably would support this action myself.
So let's turn to another withdrawal by the Trump administration. As you know, National Security Advisor John Bolton also announced the withdrawal from the 1961 optional protocol to the Vienna Convention on Diplomatic Relations. Can you speak to that?
That was a little more surprising, and of course, I'm not fully briefed on all of the reasons, but that struck me, Catherine, as an overreaction. So the state of Palestine filed a case against the United States in the ICJ at the end of September under the Vienna Convention on Diplomatic Relations optional protocol for dispute resolution, and alleging that the United States had violated the Vienna Convention by moving its embassy from Tel Aviv to Jerusalem while the status of Jerusalem was unsettled. Within 10 days' time, a National Security Advisor, John Bolton, announced that as a result, the United States was withdrawing from the optional protocol under the Vienna Convention. that seemed to me to be both surprising and an overreaction for several reasons. One, it was interesting to me that that was announced by the National Security Advisor rather than by the Secretary of State. The Vienna Convention on Diplomatic Relations, of course, is the principal treaty and a very important one that protects our diplomats and our diplomatic facilities all around the world. So if we were going to do anything to it, you would have thought that that would be within the province of the Secretary of State. By withdrawing from it, it of course prevents us from bringing any actions against other countries for violating the Vienna Convention if we have withdrawn from the optional protocol. And frankly, it seemed unnecessary.
So, John, what about the downsides to the withdrawal from the optional protocol? What are your views on those?
So it was surprising to me that the administration felt it necessary to pull out of the optional protocol simply because the state of Palestine had brought this suit. There had not been a pattern or practice of other states suing the United States under the optional protocol. In fact, I'm not aware of any other case, or at least not one in recent times. So simply that the state of Palestine had sued the United States under the Vienna Convention didn't mean that the United States was under tremendous risk of assault here. I think we have excellent defenses, the United States, in this case as to whether the court has jurisdiction. So I think, frankly, it's likely that the United States would win. So to pull out of the optional protocol simply because Palestine had sued the United States seems like an overreaction. It will cost the United States because now the United States cannot use the optional protocol to bring cases against other states. It hasn't, to my knowledge, done so ever before, but still we're giving up a tool in our own diplomatic toolkit. John Bolton, in announcing the withdrawal from the optional protocol, cited the Bush administration's withdrawal from the similar optional protocol to the Vienna Convention on Consular Relations, which the United States did when I was legal advisor. But the two cases are very different. And with respect to the Vienna Convention on Consular Relations, the United States had been sued by three different countries, by Germany in the Legrand case, by Paraguay, and then finally by Mexico in the Havana and Medellin cases. And I had argued the Medellin case, and it became clear that other countries whose nationals were inadvertently not given consular notice when arrested in the United States would continue to keep suing the United States. So while it was unfortunate that we had to withdraw from the Vienna Convention, there was a pattern and practice of states suing us and winning, and no sign that that would stop. So as legal advisor, I reluctantly agreed that while we would litigate the cases, that we would withdraw from the optional protocol. In this case, there's no sign that other states are going to be suing us under the Vienna Convention on Diplomatic Relations. So while it's annoying that the state of Palestine did so, I frankly would have just defended the case rather than pulling out of the optional protocol.
Thanks, John.
Great to be with you. Thanks, Catherine.
Thanks for listening, everyone. If you like the podcast, please look for International Law Behind the Headlines on iTunes.